Provisions applicable to particular categories of migrant workers and members of their families. Article 57. The particular categories of migrant workers and members of their families specified in the present part of the Convention who are documented or in a regular situation shall enjoy the rights set forth in Part 3 and, except as modified below, the rights set forth in Part 4. Article 58. 1. Frontier workers, as defined in Article 2, Paragraph 2a, of the present Convention, shall be entitled to the rights provided for in Part 4 that can be applied to them by reason of their presence and work in the territory of the state of employment, taking into account that they do not have their habitual residence in that state. 2. States of employment shall consider favorably granting frontier workers the right freely to choose their remunerated activity after a specified period of time. The granting of that right shall not affect their status as frontier workers. Article 59. 1. Seasonal workers, as defined in Article 2, Paragraph 2b, of the present Convention, shall be entitled to the rights provided for in Part 4. That can be applied to them by reason of their presence and work in the territory of the state of employment and that are compatible with their status in that state as seasonal workers, taking into account the fact that they are present in that state for only part of the year. 2. The state of employment shall, subject to Paragraph 1 of the present article, consider granting seasonal workers who have been employed in its territory for a significant period of time the possibility of taking up other remunerated activities and giving them priority over other workers who seek admission to that state, subject to applicable bilateral and multilateral agreements. Article 60. Itinerant workers, as defined in Article 2, Paragraph 2e, of the present Convention, shall be entitled to the rights provided for in Part 4 that can be granted to them by reason of their presence and work in the territory of the state of employment and that are compatible with their status as itinerant workers in that state. Article 61. 1. Project-tied workers, as defined in Article 2, Paragraph 2f, of the present Convention, and members of their family shall be entitled to the rights provided for in Part 4 except the provisions of Article 43, Paragraphs 1, b, and c, Article 43, Paragraph 1, d, as it pertains to social housing schemes. Article 45, Paragraph 1, b, and Articles 52 to 55. 2. If a project-tied worker claims that the terms of his or her work contract have been violated by his or her employer, he or she shall have the right to address his or her case to the competent authorities of the state which has jurisdiction over that employer, on terms provided for in Article 18, Paragraph 1 of the present Convention. 3. Subject to bilateral or multilateral agreements in force for them. The states parties concerned shall endeavour to enable project-tied workers to remain adequately protected by the social security systems of their states of origin or habitual residence during their engagement in the project. States parties concerned shall take appropriate measures with the aim of avoiding any denial of rights or duplication of payments in this respect. 4. Without prejudice to the provisions of Article 47 of the present Convention and to relevant bilateral or multilateral agreements, states parties concerned shall permit payment of the earnings of project-tied workers in their state of origin or habitual residence. Article 62. 1. Specified employment workers, as defined in Article 2, Paragraph 2g, of the present Convention, shall be entitled to the rights provided for in Part 4, except the provisions of Article 43, Paragraphs 1, b, and c, Article 43, Paragraph 1, d, as it pertains to social housing schemes. Article 52, and Article 54, Paragraph 1, d. 2. Members of the families of specified employment workers shall be entitled to the rights relating to family members of migrant workers provided for in Part 4 of the present Convention, except the provisions of Article 53. Article 63. 1. Self-employed workers, as defined in Article 2, Paragraph 2h, of the present Convention, shall be entitled to the rights provided for in Part 4 with the exception of those rights which are exclusively applicable to workers having a contract of employment. 2. Without prejudice to Articles 52 and 79 of the present Convention. The termination of the economic activity of the self-employed workers shall not in itself imply the withdrawal of the authorization for them or for the members of their families to stay or to engage in a remunerated activity in the state of employment except where the authorization of residence is expressly dependent upon the specific remunerated activity for which they were admitted.